Hello, and welcome to About Face Part 2, Compliance and Litigation Defense Strategies for Companies Using Biometric Information. If you have any questions during the webcast, please submit them via the Ask a Question text box on your viewing console. I would now like to turn it over to Frank Nolan. Thank you, Mr. Nolan. You may begin.
Thank you. Hello, and welcome to About Face Part 2. Discussion of biometrics and the law, a follow-up to our webcast from October 2018 that introduced many of the topics that we're going to dive into a little more deeply today. I'm Frank Nolan. I'm with Eversheds Sutherland. I sit in the New York office, and I'm in the litigation group. I'm joined by Emily Bork, who's also in the Eversheds Sutherland litigation group, and Emily sits in our Washington, D.C. office. Before we get to the substance of today's presentation, three quick housekeeping notes. First, if you'd like to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form. You can do so from your viewing console and follow the instructions for submission. During the webcast, we're going to provide a code for you to enter on the CLE form so you can get that CLE credit. Number two, for all of those who wish to participate, we're going to be playing a trivia game of sorts here today. So if you attended the last webcast, you'll recall that our trivia was Halloween focused. Throughout this webcast today, we're going to ask a few trivia questions related to the season of summer, and then if anyone gets them all correct, we'll mail you a fun prize. So to play, you'll see four questions over the course of the presentation. Once the presentation's over, email me or email Emily or both of us with all of your answers in one email, and we'll get back to you. Please do not enter the answer in the chat or the question boxes. That said, for number three housekeeping notes, if you do have questions for us, type them into the question box on the console. If we can, we'll address any questions at the end of the webcast if we have time. If we don't get to your question during the webcast, we'll reach out to you individually with our response. So now let's get started with our first trivia question, and I'm going to turn it over to Emily.
Okay, thanks, Frank. To start things off, our first question is, the famed mustard belt is given out as the prize at which summer sporting event? Is it A, the U.S. Open for golf, B, the U.S. Open for tennis, C, Nathan's hot dog eating contest, or D, America's Cup? As Frank mentioned, please email all of your answers at the end of the webcast to either Frank or me. All right, Frank is now going to take us from mustard belts into the world of biometrics.
Thanks, Emily. So why biometrics? Let's begin with a little bit of a catch-up, an overview of I just realized the mustard ketchup pun, that's terrible. Let's begin with an overview of our prior webcast on biometrics. This is back in October 2018. We discussed some background on biometrics, a little bit of the history, which, believe it or not, dates back thousands of years. We provided with some fun examples, and we also provided some, frankly, unsettling examples of biometrics already in use. We discussed some areas of further development in those areas. We gave an overview of some of the more noteworthy laws. We talked a fair bit about the Illinois Biometric Information Privacy Act, known as BIPA. We provided background on the law, some case law, and we did note that that is still a very developing area of law. We also jumped across the pond, and my colleague David Cook from our Manchester, UK office provided some information on the GDPR's relevant guidelines on biometrics. And finally, we touched briefly on compliance. So if you'd like to get up to speed on any of that, please visit our website where you can watch and listen to the webcast from October for free. So all that said, we think that today's webcast can stand on its own. So what are we going to cover today? Like last time, we're going to get into some technical basics, albeit in less depth. We'll update you on some recent developments that fall into the category of the unsettling developments that I mentioned before. But the bulk of today will be devoted to a deeper dive into the relevant statutes and areas of concern. We're going to discuss BIPA as we did last time, but this time we're going to focus more on possible defense strategies if you're facing a class action arising from alleged BIPA violations. We're going to talk to you about some of the recent case law from the Illinois Supreme Court and various federal district and appellate courts. We're going to explain some of the as-yet untested defense arguments, and we're going to get into some of the real-world blowback that Illinois has faced as a result of the BIPA legislation that's resulted in so much litigation. But BIPA doesn't apply to every company, or even every company that does business in Illinois or with Illinois residents. So we'll also cover some other things. We're going to talk about the California Consumer Privacy Act, or CCPA, which is going to go into effect next year. We're going to talk about how the CCPA will treat biometric information and how the law could be amended prior to 2020 in ways that will impact or may impact how biometric information must be handled. We're also going to get into some of the other biometric statutes in the U.S., both enacted laws and laws that are being proposed in state legislatures around the country. And that's sort of the theme here today. BIPA in Illinois is the most extreme law in the book, for lack of a better word, but it's not the only law, and it will not be the last one. That is just a guarantee. So it's not enough to assume that the landscape won't change as far as consumer protections for biometrics, and it won't always be enough to follow industry standards. So while BIPA may not be word for word what your company needs to comply with, it's a tremendous resource for applying common sense, practical, and not too burdensome compliance measures. And that's the last focus of our webcast this morning, or this afternoon, compliance. We'll get into strategies and tactics for smart compliance with some existing and nascent laws, and talk about troubleshooting in that regard. So without further ado, I'll turn it over to Emily to get us started.
Thanks, Frank. So as an initial matter, what is biometric data? What does it consist of? Perhaps the easiest way to think about information that falls within the scope of biometric data is to consider your own immutable characteristics, or in other words, information that makes you unique. Some examples of this are depicted on the slide, such as your fingerprints, face, and iris. All of these are examples of biometric data. Biometrics can essentially mean anything that contains certain biological traits that are unique to each individual. And given that biometric data is unique to each individual, it is increasingly being used by a wide range of institutions, as it is arguably more secure than, for example, traditional security measures like passwords or codes. Biometric data is also used for a variety of purposes in areas such as marketing, advertising, national security, and personal identification protection. For example, biometric data can be used for individual verification to confirm a person's identity, such as when you're using a fingerprint scan to access your phone, or when you use facial recognition technology at a security screening checkpoint at an airport, for example. When biometric data is taken from you, whether that's through a fingerprint, retina, or facial feature scan, it is stored in an algorithm, which consists of a series of random numbers and letters that are intended to be impossible to reverse engineer or decode. And that is one of the purported benefits of biometrics, that biometric data is essentially de-identifiable, or it can't be cracked. But whether that's entirely accurate is a point of contention and remains an open question. So I'm going to turn it back over to Frank, who is going to discuss some of the benefits and potential risks associated with biometric data.
Okay, thanks, Emily. So why biometrics? Simply faster and more convenient for users. Most of the time, there's no more passwords to remember. You use your fingerprint and your eye to scan in to open your phone, get into your bank account, get into a secure area at work, clock in at the beginning of your shift, and so forth. The authentication is strong since biological characteristics are distinct and unchangeable with obvious strange exceptions. It's potentially more secure than passwords, and it shifts the burden and I'm not using that in a legal sense, but the burden of from the user to the company. So if you are using a traditional password, you've got to remember that password among all your other passwords, so you bear some of the burden in maintaining security for your different accounts, for example. When that is just a matter of you scanning your thumbprint, that burden is shifted from you to remember that to entirely to the company who's collecting it to maintain it and keep it secure. So there's some of the advantages of many of biometrics. On the other side of the scope, why are legislators, regulators, and most notably the public concerned about biometrics? This is a recent headline from the New York Times. It is not hard to find similar headlines in the last year or two, especially along the lines of this one. So there are recent laws and proposed laws banning facial recognition technology. It creates a unique cybersecurity risk, as Emily hinted at. Unlike other identifiers, biometrics can't be changed, again, generally speaking, if they're compromised. There are police state concerns. This is certainly true in China, as recent news stories have demonstrated, and those concerns have reached our shores as well. In fact, a recent study from Georgetown Law estimates that 1 in 4 Americans are already in a police facial recognition system. And that's a result of the fact that at least 52 law enforcement agencies nationwide already use facial recognition technology. San Francisco, as you can see here, recently banned the police and government agencies in that city from using facial recognition technology. Some private companies have been fostering law enforcement use of facial recognition technology. Potential bias is a risk that's based on the use of biometrics, including because of misidentification of individuals through facial recognition technology. There are general privacy concerns that you can imagine, and very few states regulate the collection and storage and the use of biometrics. There's no federal overarching statute governing biometrics, so there's a vacuum. Move on to the next slide. Continuation of some of these concerns. Let's talk about the federal government. A few weeks ago at a congressional hearing, there were several comments from experts in the area of biometrics as to the risks associated with unchecked collection and use of biometrics, most of these in the context, but not all in the context of facial recognition technology. These quotes may seem alarmist, but they're really not outside of the mainstream. The bolded one at the bottom there, our faces may well be the final frontier of privacy. That's an interesting perspective, and just gives you sort of an overview of what we're talking about here in terms of concerns that have really reached the forefront of the popular mindset. So let's talk about the legal framework. I mentioned a vacuum. Well, we're going to begin with some of the states that have directly addressed biometrics and separate statutes, apart from the more overarching privacy laws that may incorporate biometrics into them. In some states, biometric information is explicitly incorporated in the statutory law. In others, there's a vacuum, and on the federal law, there's frankly not much out there. So the question becomes, for most companies that are or are not or may not be subject to any specific state statute, how do you operate in that vacuum, right? Doing nothing is rarely the best approach. So I think this overview of what's out there may help with some guidance. May not provide the answers you're looking for, but may provide some helpful tips. So I'm going to turn it back over to Emily, and we're going to begin with the Biometric Information Privacy Act.
Okay, thanks, Frank. Starting with the Biometric Information Privacy Act, this statute was enacted by Illinois back in 2008, and Illinois really is at the forefront regulating this space. So let's dive into BIPA a little bit further. BIPA is arguably the most robust and stringent statute that is currently on the books regulating biometric data. BIPA regulates companies that collect, store, use, or profit from biometric data belonging to Illinois residents. But there are important exceptions within BIPA. Only private non-governmental entities are subject to BIPA, and financial institutions that are subject to the Gramm-Leach-Bliley Act of 1999 are not subject to BIPA. So what is the scope of BIPA? Later on, we are going to discuss defenses to biometric data claims, and we will go into the geographical scope of BIPA. But for now, what is the substantive scope? What type of data does it apply to? BIPA regulates the collection, use, safeguarding, handling, storage, retention, and destruction of biometric identifiers and information. So as you can see, it covers a wide range of activity. And biometric identifiers that are subject to BIPA include some of the biometric information that we highlighted earlier in the presentation, including retina or iris scans, fingerprints, voice prints, and scans of hand or face geometry. But at the same time, it's also noteworthy to discuss what BIPA does not consider biometrics. Things like writing samples, written signatures, demographic data, even tattoo descriptions, or physical characteristics like your height, weight, eye, and hair color are not considered biometric data under BIPA. BIPA requires that companies get written consent from individuals from whom biometric data is collected, and that consent has to state why and for how long the biometric data is being collected. The consent then also has to be executed by that individual or the individual's legal representative. BIPA also requires that private entities develop and follow a written, publicly available policy for their retention and destruction of these biometric identifiers. Companies are also prohibited from selling or otherwise profiting off of an individual's biometric data. And because BIPA is an Illinois statute, it's not surprising that the case law we have on BIPA is coming out of Illinois state courts and federal courts in Illinois, particularly the Northern District of Illinois. So what type of BIPA claims have we seen? Well, plaintiffs have brought BIPA claims against their employers, arguing, for example, that they were required to use a fingerprint scan to clock in and out of work or for timekeeping purposes, and they never consented to do so. But technology and social media companies have also been the subject of BIPA claims, like Shutterfly and Facebook. Facebook, for example, and its tag suggestion feature, where Facebook provides a pre-selected name to a particular face. It matches a name to a face in a user's photo for tagging purposes. That has been the subject of suit in the Northern District of Illinois back in 2016. So this really shows that as the industries using biometric data become more diverse, so too do the potential BIPA defendants. All right, turning now to BIPA penalties. What makes BIPA so powerful is that it provides a private right of action to individuals, allowing them to bring suit and pursue a claim if they believe they have been harmed, or in other words, if they believe their biometric data has been collected or otherwise taken without their consent. Each violation of BIPA is considered a distinct harm that allows plaintiffs to seek statutory damages. And under each violation, plaintiffs can recover anywhere from $1,000 to $5,000, depending on whether the violation was negligent or more serious, i.e. reckless or intentional. And these potentially high statutory damages under BIPA, not surprisingly, can also drive up settlement demands. And Frank is going to discuss settlement considerations more deeply later in the presentation. But it's also important to note that BIPA can be considered a fee-shifting statute. So that means that BIPA allows the prevailing party to recover their reasonable attorney's fees and costs, including expert witness fees, which can be pretty steep, and litigation expenses. Now, this is contrary to the typical American rule that we see in litigation, under which each side generally bears its own costs and attorney's fees. All right, so we are going to transition to a lighter topic away from liability for the moment and take another trivia question. Again, like Frank said at the beginning of the presentation, please email all of your answers at the end to either Frank or me. So, which days of summer between July 3rd and August 11th are named for the figure Sirius in the Canis constellation? Is it A, the hot days, B, the dog days, C, the humid days, or D, the I wish it were Friday at 5 days?
Okay. So we've seen what the landscape is as far as BIPA, and we're going to discuss some of the defense strategies, some of the case law, some of the unanswered and undeveloped and underdeveloped areas, and other relevant considerations for parties facing or potentially facing BIPA class actions. I think this is good background on consumer protection lawsuits generally. However, as many of the same principles apply here, certainly these could come up if and when additional states enact laws of private rights of action, and these principles are not exclusive to BIPA, but I think they're interesting. So I'm going to turn it back over to Emily to talk about the first line of defense.
Great. Okay, so let's get into Article 3 standing. Article 3 standing is a U.S. constitutional requirement. Federal courts have the power to hear only cases and controversies, which has been interpreted by federal case law to mean that plaintiffs must demonstrate an injury in fact or a concrete actual harm in order to proceed with litigating their case in federal court. But there is a lower standard in Illinois State Court following the Six Flags decision by the Illinois Supreme Court in January of 2019, which we will discuss further in a few moments. In that case, the Illinois Supreme Court held that alleging a statutory violation under BIPA is enough for the plaintiff to proceed with the case and survive a motion to dismiss based on a standing defense. So the million-dollar question really becomes then, is being an aggrieved person under BIPA enough to satisfy standing? Well, the answer seems to be no, at least not for the Northern District of Illinois. Even if the plaintiff is aggrieved under BIPA, which, by the way, is not defined under the statute, that alone may not be sufficient to satisfy Article 3 standing. And the Northern District of Illinois held that as recently as 2018. But the answer to the question of is being aggrieved enough based on the Illinois State Court is likely yes. Again, coming out of the Illinois Supreme Court's decision in the Six Flags case. So let's talk about the Six Flags case a little bit more deeply. This was a decision, like I said, coming out of the Illinois Supreme Court in January of 2019. Here the plaintiff argued that the Six Flags theme park was collecting fingerprints from season pass holders without their consent. The Illinois Appellate Court held that the class representative did not suffer an actual injury that was sufficient to confer standing, but the Illinois Supreme Court reversed and held that plaintiffs do not need to allege actual harm to pursue their BIPA claim, at least in Illinois state courts. Rather, an allegation of a statutory violation under BIPA is enough. So what is the impact of the Six Flags decision? Well, quite simply, more and more lawsuits are being filed in Illinois state courts surrounding BIPA based on this seemingly more liberal standard for standing. Turning to the in re Facebook Biometric Information Privacy litigation suit, this is a consolidated case of several related cases, and it's currently in the federal courts in California. In this case, it's a class action. The named plaintiffs argued that Facebook collected and stored their biometric information without consent or prior notice. In 2018, the Northern District of California held that a violation of a right to privacy, which is codified or set forth in BIPA, that constitutes a concrete harm sufficient for Article 3 standing. So the Facebook case arguably seems more in line with the recent Six Flags decision, where an allegation of a violation under BIPA was enough to satisfy even Article 3 standing, according to the Northern District of California. The class in this case was certified in April of 2018, and the case is currently stayed, pending Facebook's appeal of class certification. Frank is now going to discuss the removal doctrine and geographical considerations to keep in mind when defending privacy claims.
Thanks, Emily. So a good general rule of practice in litigation, particularly in the class action context, is if you get a complaint filed in state court, you want to get to federal court if at all possible. It's just a general rule of thumb. It's more predictable. The judges are typically less burdened in the class certification context in particular, and in some other substantive areas, the law is simply just better and more favorable. That said, removal is a funny thing in the context of BIPA litigation and comes with some potential unforeseen risks. And this is the result of the case law Emily discussed earlier, and in particular, the Six Flags decision, whereby the Illinois Supreme Court found that a plaintiff doesn't have to satisfy the aggrieved person standard to bring a BIPA claim other than claiming a violation of the law. And that's in stark contrast to the vast majority of federal decisions involving BIPA claims, where federal courts, at least in the District of Illinois, have overwhelmingly found that a party has to allege some form of harm, even a small one, to satisfy the Article III standing requirement. There's no such requirement in the Illinois Constitution. So one would think that this further incentivizes parties to remove complaints from state to federal court and then move to dismiss for lack of standing, since most of these complaints don't allege an independent harm other than a bare bones violation of BIPA. The problem is, as some defendants have found, is that if there is no standing, then the federal court may not have jurisdiction, which means that the federal court will then kick the complaint back to the state court instead of outright dismissing the complaint. So then you're right back to where you started. What's worse is that some federal courts have even required the removing defendant to pay the attorney's fees for the plaintiffs for wasting the time and resources to remove and then, or to oppose removal and then oppose a motion to dismiss for no real reason. So while there are tremendous advantages in removing a federal court, consider your strategy when you get there. It may not involve moving to dismiss for lack of standing. You may end up getting a little bit more than you bargained for. Now, similarly, it may occur to you, once you have moved to federal court, that you want to transfer to a venue closer to home. So let's say, for example, your business is located outside of the state of Illinois, and you'd like to, and it would make more sense for you and just be easier to litigate the case in federal court in California, applying the Illinois rule. And that's exactly what Facebook did in the case that Emily was just talking about. Unfortunately, the case was transferred to a Northern District of California judge who stands in the stark minority on the question of whether a plaintiff must plead an injury separate from a violation of the BIPA statute to survive a motion to dismiss challenge. And as you saw, the judge denied the motion to dismiss, granted class certification, and now the case is before the Ninth Circuit, as Emily discussed. If that case had been before a Northern District of Illinois judge, it likely would have been dismissed. So once again, be careful what you wish for. So if you can't argue standing at a motion to dismiss stage, or maybe it doesn't make sense for you to do so based on what we just talked about, what are some other defenses that a defendant can consider in the alternative?
Okay, so let's dive into some other defenses a little bit more deeply. As you can see, we broke these down into statutory and more constitutional-based defenses. Starting with statutory defenses and failure to state a claim. This argument is raised via a motion to dismiss, and the crux of this argument is that the complaint is legally insufficient. It is defective or deficient somehow. But there are costs and benefits of raising a motion to dismiss on failure to state a claim. For example, even if the motion to dismiss is granted, plaintiffs may seek leave or the opportunity to amend their complaints and potentially correct the deficient portion or portions. So even if you have a successful motion to dismiss it may only be a temporary win, and it may not resolve the entire litigation. Extraterritoriality. This defense relates to the geographical reach of the statute. For BIPA, the Northern District of Illinois has held that BIPA does not apply outside of Illinois. But as you can imagine, this is a very fact-intensive defense. So its strengths or its merits may not be fully known until at least some information has been exchanged between the parties in discovery. Next up, we have the claim being outside of the statute's scope. This defense is really rooted in the substance of the statute or the law itself. Now, Shutterfly and Facebook have raised these arguments, claiming that BIPA does not apply to individuals' photos and information derived from photos, and they focused on the definition of biometric information under BIPA that we discussed earlier to raise this defense. Lastly, under statutory defenses, we have the statute of limitations. This defense is that the plaintiff did not bring the lawsuit within the required time period. The plaintiff essentially missed the expiration date to file suit. This is somewhat ambiguous, at least for BIPA claims, because BIPA does not specify an actual statute of limitations within the law itself. Turning to more constitutional-based claims under both the Due Process Clause and the Dormant Commerce Clause. Under the Due Process Clause, we have personal jurisdiction and damages. Circumstances that are really ripe for a potential personal jurisdiction defense are when there is an out-of-state defendant that conducts limited or even no business or conduct within the state where the case is pending. The strength of this defense, at least within the Northern District of Illinois, is still developing. The Northern District of Illinois has both granted and denied motions to dismiss, asserting lack of personal jurisdiction. A damages defense under the Due Process Clause is rooted in the idea of fairness, the argument being that the potentially high statutory damages under BIPA are unrelated or disproportionate to any potential minor harm the plaintiff may have suffered. Lastly, the Dormant Commerce Clause prevents state statutes from discriminating against or excessively burdening interstate commerce or activity that occurs outside of the state. This is somewhat related to the extraterritoriality defense. It deals with the geographical scope of the statute. But like the extraterritoriality defense, this is a very fact-intensive and fact-dependent defense to raise. So again, the strength or merits of that defense would more likely need to be developed as discovery has taken place. I'm going to hand the mic back over to Frank to discuss class certification.
Before we do that, we're a little bit past the halfway point. So for those of you who would like to receive CLE credit for today's webcast, the confirmation code is About Face, so the title of the webcast. Please use this code for the sign-in sheet available for download from your viewing console. Again, if you'd like to receive CLE credit for today's webcast, the confirmation code is About Face. All right, class certification. So other challenges and other negotiating points for BIPA and potentially under other laws, generally speaking, they arise from class certification. And let's just talk about this in the context of the Federal Rule 23 requirements for class certification, numerosity, commonality, or numerosity, so you have to have enough members of the class, commonality, common issues among class members, typicality, the class representative's claims are typical of the class, adequacy of the class representative, predominance, which is related to the commonality requirement. And then there's the unstated requirement in many courts, in many circuits, of ascertainability, meaning that you have to be able to actually determine who's in the class, who's a member. So potential BIPA fact patterns ripe for commonality and typicality and predominance challenges arise from different facts regarding consent. So the class representative did give consent or did not give consent, but other class members did or did not. Maybe some of the class members signed employment contracts by which they consented to having their biometric data collected. Scenarios differ among potential class members that are too individualized or fact-intensive for a finding of class certification. Now, I mentioned the possibility of, we're not going to get into the case law on class certification here, largely because it's quite undeveloped in the BIPA context, but also just because of time constraints. But I mentioned the possibility of negotiating settlements in this context. So let's touch on settlement considerations a little bit. Now, given that the law is still fairly undeveloped, and given that many of the publicly available settlements preceded the Illinois Supreme Court's decision in the Six Flags case from January, evaluating the settlement value of these class actions can be difficult. We have seen public class settlements into the low seven figures so far, which is obviously, in most cases, much lower than the potential liability for many of these putative cases, and for the smaller cases, a bit lower on the total value, but higher on the per class member basis. And we've seen per class member recovery ranging from as low as $40 to as high as over $1,000. I think the highest one I've seen per class member recovery is about $1,200. And this is obviously setting aside attorney's fees. Those settlements often speak in terms of harmed individuals rather than number of BIPA violations. The sums recovered do often reflect the alleged number of individual harms of individuals who were harmed, which is a distinction that often gets blurred in these kinds of consumer protection statutes, where the statutory recovery is intended to be on a per violation basis, not a per person basis. But typically when you're settling a class, it's easier to just settle on a per individual or per class member basis. So we mentioned at the top of the webcast the potential for blowback. This is a recent article. Unsurprisingly, companies are seeking to fight BIPA through lobbying efforts, as well as working to ensure that similar statutes are not enacted in other states. One of the efforts has been to limit the private right of action provided under BIPA, which would stem the flow of BIPA lawsuits that's currently flooding the courts. So far, all such legislative efforts have died on the vine, testament to the power of the plaintiff's bar, no doubt, and something of a warning sign for other states. And I'm looking in your general direction, California. Google has ceased selling its fully operational Nest product in retail outlets in the state of Illinois. So the Nest product is a feature that uses facial recognition technology as a security component. It does so to screen individuals who, say, for example, approach your front door, and it runs their images against its internal database of known persons. Now, due to the obvious risks involved with collecting that information in the state of Illinois without getting the consent of the individuals or standing on your front porch, Google disabled that component in its products sold through retail in the state. Now, that's a relatively minor example, but as the wave of BIPA suits continues to grow, there could very well be more activity on the part of Illinois businesses to take such measures, including up to leaving the state altogether. And that's exactly the kind of thing that legislators in California have warned about with respect to the CCPA, for example. They simply don't want to be seen as anti-business, and that's the view some companies are taking in Illinois, even if it is 11 years now after BIPA was enacted. So we've talked a bit about BIPA. Let's move on to some other jurisdictions. All the decisions that Emily talked about arise from BIPA. That Illinois statute remains the only statute on the books that provides for a private right of action arising from just the collection and consent of biometric data. But there are other states that have been enacted that resemble BIPA. BIPA in 2008, and Texas 2009, Washington in 2017. Now, let's talk about Massachusetts for a minute, and I think it's an interesting case study. It combines some aspects of BIPA, some aspects of the GDPR, and some aspects of the California Consumer Privacy Act that we're going to talk about in just a minute. The Massachusetts law, if enacted, could result in a surge of class actions along the lines of what we're seeing in Illinois. So this is a privacy law, and it protects any information relating to an identified or identifiable customer, and it explicitly includes biometric information of all kinds into the definition of that protected information. The proposed law would also have a broader scope of what would be considered biometric information protected under the law, and would include any data that would contain identifying information, including the same categories listed in BIPA, but with some additional categories such as DNA information. Like the GDPR and the CCPA, the Massachusetts law would, if enacted, impose notice requirements relating to the collection and disclosure of personally identifying information, including biometrics. And without getting into too much of the details, since it, of course, is yet to be enacted, it's worth mentioning that the private right of action would allow for recovery of up to $750 per violation, which would make it appealing to class action plaintiffs' lawyers. So those violations would not arise from breaches, like with BIPA. They would arise from failure to abide by the notice and collection requirements. So when we discuss BIPA, it may be tempting to say, well, that particular statute doesn't apply to my company. But with more laws on the horizon, or even with the vacuum that exists now, it again, as I said earlier, it makes common sense to at least consider following BIPA, because it will not be the only statute with teeth in play for much longer. So I've mentioned CCPA quite a bit. Let's get into it. Emily?
All right, so turning to the California Consumer Privacy Act, let's discuss how biometric information will be regulated under this legislation when it becomes effective next year. As an initial note, we have held prior CCPA webinars and have another webinar on the CCPA coming up if you would like more information on this legislation. The CCPA creates a private right of action for businesses that do not take reasonable security measures. The CCPA will impose higher penalties than under BIPA. We discussed that under BIPA, penalties can range from $1,000 to $5,000 per violation, but under the CCPA, however, penalties can be up to $7,500 per violation. Like I said, the CCPA will become effective in 2020, but its enforcement may be delayed. So what kind of information does the CCPA apply to? The CCPA explicitly includes biometric information under its definition of personal information, or PI, that is protected under the law. Biometric information under the CCPA is defined to mean an individual's physiological, biological, or behavioral characteristics, including an individual's DNA, that can be used to establish a person's identity. And biometric information under the CCPA includes, but is not limited to, imagery of the iris, fingerprints, hand, palm, and vein patterns, even one's keystroke patterns or rhythms, gait patterns or rhythms, and even sleep, health, or exercise data that contain identifying information. So in this sense, the CCPA arguably has a broader definition of biometrics than under BIPA, at least based on the examples that I just provided, because, for example, BIPA is silent as to whether sleep information counts as biometric information. So the CCPA would include information collected from devices such as a Fitbit, for example, which would be valuable to insurance companies measuring an individual's health and exercise patterns. But de-identified data or aggregated consumer information and information that's made public by public authorities is not considered personal information under the CCPA. This is typically information that is not linked or does not have the capacity to be linked to any particular consumer or household. It is rather aggregate, broadened information. Now, companies that use biometric information will have to provide consumers with rights that are afforded to them under the CCPA, which includes the right to notice, the right to disclosure, the right to be forgotten, the right of access, and the right to opt out of having one's personal information be sold to other parties. There was a potential amendment to the CCPA that was introduced back in February of this year, and that would have required businesses in California to use facial recognition technology to disclose such technology through BIPA-like disclosures, basically through clear and conspicuous notice or sign that the technology was being used. But that amendment has died in committee and was removed as of the last few days. So let's turn to some federal law, for example, and see how the federal government has weighed in or not weighed in within this area. There is a general lack of federal regulation of biometric information, and that seems to stem in part from a greater learning curve that's needed to understand biometric information, at least on the federal scale. Federal legislators are really just starting to address biometrics. There was a House Oversight Committee hearing just a few days ago on May 22nd on the use of biometrics in both the private and public sector, and that hearing addressed some of the constitutional issues regarding biometrics and privacy concerns under the First, Fourth, and 14th Amendments. Congress is also considering bipartisan legislation introduced back in March 2019, the Facial Recognition Privacy Act of 2019, and that, if enacted, would require private companies to obtain consent prior to using individuals' biometric information. So it appears that for the moment, regulation efforts regarding biometrics are really concentrated in the states, but that is subject to change. So it is still important to be aware of and apprised of any federal efforts to regulate biometric information, as Congress may decide to throw its hat in the ring within this space and start regulating biometric data as well. So let's turn to the Fair Credit Reporting Act and biometrics. The use of biometric information may have implications under the Fair Credit Reporting Act. Companies that seek and obtain consumer reports, such as during background checks, may need to be mindful of how they handle such information, particularly if it relies on or reveals biometric information. And consumer reports under the Fair Credit Reporting Act are defined broadly. They include essentially any information by a consumer reporting agency that bears on an individual's creditworthiness or credit standing, credit capacity, character, or general reputation or personal characteristics that can be used for establishing an individual's eligibility for credit or insurance or even employment. And medical information currently gets special protection under the Fair Credit Reporting Act by requiring an individual's affirmative consent before their medical information can be disclosed. And the Fair Trade Commission, that federal agency, has the authority to enforce the Fair Credit Reporting Act when any information, including potentially biometric information, is used to determine an individual's eligibility for credit, insurance, or employment. So this authority that the Fair Trade Commission has may become more and more relevant as biometric information increases in connection with the use of consumer reports. All right, so we are going to take a quick break and have another trivia question. Again, please email your answers to Frank or me at the end of the presentation. The first modern version of this was held in the summer of 1896. Was it A, the Summer Olympics, B, baseball games, C, surfing championships, or D, the World Series of Poker? Now, Frank is going to introduce us to the topic of compliance.
All right, thanks, Emily. Now, let's start with BIPA compliance. Many of the compliance requirements under BIPA are fairly, and I know I'm repeating myself here, but they're fairly common sense approaches dealing with biometric information. And for companies not subject to BIPA, they may well be worth considering. So let's start with consent. Companies that collect, use, and/or store biometric information must explain to and obtain consent from individuals as to why their information is being collected, used, and/or stored. The release must be written but can be electronic. Consent may be part of an employment agreement, and that's a big one because a lot of the suits so far are coming from employees. Importantly, BIPA does not distinguish between the party that interfaces with the individual to collect the data, or we'll call the collector, and the party that stores or uses the data, i.e. the processor. So the collector, the processor. Liability can potentially extend to both or either the collector and the processor. In fact, due to this broad language, some plaintiffs have brought claims against third-party vendors that may store or use biometric data, despite the vendors never actually interfacing directly with the individuals from whom the data was collected. As a result, it's not enough to rely on the collector to obtain consent on behalf of itself and the processor. The processor should also get consent from the individual, and that consent must be expressed, written, and tailored to how the biometric data will be handled. BIPA also includes a separate consent requirement for private entities that intend to disclose an individual's biometric data. Consent to disclose must include the party to whom the biometric information is being provided, must confirm the limited purpose for the disclosure, and should include the time for which it will be maintained or stored. Next up, the retention policy. Biometric data must be destroyed by the earlier of the time at which the purpose of the initial collection has been satisfied, or 3 years from the last interaction between the collecting party and the individual. So that means there may be different statutory retention periods and schedules for different data. Importantly, this retention policy must be made publicly available, i.e. on the company's website. 2 more requirements. Number 1, entities that possess biometric data must store, transmit, and protect it using the reasonable standard of care in that entity's industry, and in a manner consistent with how the entity handles other sensitive information. Number 2, the collecting and processing party may not profit from the biometric data. Now, whether that's selling, leasing, trading, marketing, whatever, you can't do it. This hasn't yet been subject of any BIPA suits that I've seen, but that doesn't mean it won't be in the future once plaintiffs' firms have knocked off all the low-hanging fruit that they're making their money off of right now. One side note, and that's on the issue of photographs. In a situation where a person, and this is under BIPA, in a situation where a person's facial features are scanned and stored, that is definitionally biometric identifier. That said, what if a company collects a photograph of a person? Is that photograph biometric information? The answer is pretty clear that it's not. But a third scenario, if the company scans the photograph as opposed to the person, and that scan could then be considered a biometric identifier. As one court put it, quote, BIPA does not specify how the biometric measurements must be obtained, and the bottom line is that a biometric identifier is not the underlying medium itself or a way of taking measurements. Instead, it's a set of measurements of a specified physical component, eye, finger, voice, hand, face, used to identify a person. And that can come from a photograph. So to view a scan of a photograph otherwise, as one court put it, would be a narrow or problematic reading of BIPA. Now let's briefly discuss compliance under some other laws. And Emily's going to talk about CCPA.
Okay, based on what we discussed earlier regarding the CCPA, we are now going to turn to compliance under the statute. How can companies seek to be in line with the letter of the law under the CCPA? The primary ways in which entities can seek to comply with the CCPA is to really track collected data to ensure that they are abiding by the requirement to honor individuals' rights with respect to their data. Under the CCPA, as we discussed, individuals have the right to notice, the right to disclosure, the right to be forgotten, the right of access, and the right to opt out of having their personal information be sold. Additionally, companies that store biometric data should ensure that they have a robust data security system and measures in place, given the potential for class action liability under the CCPA. And that is particularly important because, as we discussed, the CCPA will have higher statutory damages per violation of up to $7,500, as opposed to BIPA, which range from $1,000 to $5,000 per violation.
We have a brief slide on Fair Credit Reporting Act compliance. Unfortunately, we're a little short on time. Let us know if you want us to get into that specifically. More importantly, summer trivia, final question. July is National What Month? National Ice Cream Month, National Hot Dog Month, National Blueberry Month, or all of the above? All right. We have covered a lot of ground today, particularly in conjunction with our prior webcast. As is, I think, is evident, even when comparing the two webcasts just several months apart, the law is developing quickly, even if it does still lag far behind the technology. I mean, some of the decisions that we talked about that are very important today, they weren't on the books on our last webcast. That pace is going to continue. Unfortunately, there's some issues we simply didn't get to today. There's other proposed state legislation. I gave the Massachusetts law as an example. There's the GDPR. Those areas are ripe for discussion. There are practical issues. Indemnity provisions when dealing with vendors who you may partner with in collecting, using, or storing biometrics. There's the issue of insurance coverage, which is a very undeveloped area with respect to biometrics, and that frankly leaves more questions than answers. So if you have specific questions as to those topics or anything else, feel free to let us know. In any event, we hope this was helpful, and please feel free to reach out to either of us with any questions or comments. Keep an eye out for future articles and webcasts from us, including, as Emily mentioned, the CCPA webcast is coming up this summer. If you entered a question in the discussion box, we'll get with you directly. And as a reminder, if you'd like to receive CLE credit for this webcast, download the sign-in sheet and the evaluation form from your viewing console, follow the instructions for a submission, send it in, and finally, a copy of the slide deck will be circulated following the presentation. So thanks. We're right at about an hour. Thank you for your time. Enjoy the rest of your day.